Good afternoon. For those who don't know, this is the Senate Judiciary and Public Safety Committee. And for the record, this is Monday, March 2nd, 2020. We will begin with Senator Miller's Senate File 3564. Now, Senator Miller, I just wanted to let you know that despite the fact that you have that lofty presidential title of the Senate, we're going to treat you exactly like every other senator that comes before the Judiciary Committee.
Well, thank you, Mr. Chair and members, and you should know that strategically I try to avoid this committee, and even as president of the Senate, I couldn't do it on this bill, so I'm here. No, I'm just kidding, of course.
We always love to have you. Why don't you explain your bill, and then we can get to your testifiers. Thank
you, Mr. Chair and members. Today I'm here to present Senate File 3564, which is a bill to appropriate $30 million from the general fund to the Disaster Assistant Contingency Account. State Representative Gene Plowski from Winona deserves a lot of credit, along with Senator Cohn and many others, for creating the Disaster Contingency Account in 2014 to allow the state to make prompt payments to local communities for costs arising from natural disasters without the governor having to call a special session of the legislature to appropriate emergency funds. This, of course, is the case as long as there are sufficient funds in the account. In my conversations with Director Kelly, who we will hear from shortly, the Disaster Assistance Contingency Account has been used 40 times since it was created in 2014, and the legislature has appropriated $82 million into the account since 2014. Due to higher than expected damage assessment costs due to spring flooding in 2019, there is currently a deficiency of $3 million in the account. This $30 million appropriation will take care of the deficiency as well as prepare the state for future natural disasters. We hope that they don't happen, but we need to prepare if they do. So with that, Mr. Chair and members, I'd like to bring up Director Kelly, and then I know we have a couple other testifiers as well.
Thank you, Senator Miller. Director Kelly, would you identify yourself for the record?
Yes, Mr. Chair and members, good afternoon. For the record, my name is Joe Kelly. I'm the Director of the Division of Homeland Security and Emergency Management with the Department of Public Safety. Thank you for the opportunity to provide some basic background information on the Disaster Assistance Contingency Account, give you an update on its current status, and present a very quick explanation of the Governor's recommendation to replenish the account. As Senator Miller alluded to, this account was established in 2014. It provides assistance to local units of government, so financial relief to local units of government following natural disasters and other events. It pays two primary categories of expenses. One is if there's a federally declared disaster where the president authorizes the state assistance from FEMA, it will pay the 25% non-federal share. We typically often refer to that as the match. The feds will pay 75%, and then this account pays the 25%. Absent of federal aid, when there's a disaster that is not of the severity and magnitude to merit, if you will, federal disaster assistance, the governor has authority under Minnesota Statutes Chapter 12B to authorize disaster assistance, and then those percentages are reversed. This account, if the governor authorizes its use for an incident, will pay 75% of the eligible damages. The remaining 25% is borne by the local applicants. This account, since it was established, it has the legislature has not had to meet in special session in order to appropriate funds for disaster assistance. As you can see from this slide, the last 2 years, as Senator Miller mentioned, the last 2 years have been very challenging for local governments in dealing with floods, tornadoes, windstorms, ice storms, etc. We have received 3 federal declarations with impacts across 80 counties and 7 tribal governments, and accounting for about $100 million of uninsured damage to public infrastructure. And by that, we're talking about things like removal of storm debris from streets, the repair and restoration of rural electric power, cooperative service, to rebuilding roads and bridges. On the state side, and just in the last 2 years alone, of the 40 that Senator Miller mentioned, 16 of those state declarations have been made in the last 2 years, impacting 30 counties, 1 tribal government, in a total of $20 million of damage. So you can see between the state and the federal programs, the support coming out of this account has helped local units of government with $120 million of eligible damage. And local units of government simply do not have those kinds of reserves in their budgets to deal with these kinds of events. To take it down a little more granularly, there are we are currently working with more than 1,400 applicants for assistance. Cities, counties, tribal governments, police departments, school districts, township boards of supervisors, 1,400 individual applicants for disaster assistance under those 19 declarations. So this account has been needed and it's been well used over the past couple of years. Just overall, the quick arithmetic for the contingency account, again, as the senator mentioned, $82 million have been transferred and or appropriated to the account since it was established in 2014. $76 million has been transferred out. It might look like we have $6 million obligation or balance in there, but we really don't, because we know there's a $9 million IOU in there for the increased costs associated with last spring's flooding and the federal declaration that went with it. That creates that $3 million deficiency that Senator Miller mentioned. The governor's recommendation is identical to the senator's bill to transfer $30 million from the general fund to fund the contingency account. The first $3 million will go to funding that deficiency. We are making some assumptions about future disaster activity, but we are hopeful that $27 million would be enough to sustain this account through the rest of the biennium. But that's a little bit like predicting the weather, and it's very challenging to do. It's really based on the performance of this account over the past couple years. We anticipate this time next year appearing before your committee and others explaining how much money the governor recommends be included in the biennial budget for the next biennium. Mr. Chair and members, that concludes that brief presentation. I stand for any questions you may have.
Are there any questions for this testifier? Senator Johnson.
Thank you, Mr. Chair. And thank you for the work that you do. I know that you were up in my district this past fall when we had flooding. You were up there with the governor, and appreciate you coming up there and working with our folks. One question I have, it just kind of goes back to the nature of this, is I'm not going to ask you about your personal views on climate change, but just as infrastructure becomes more expensive and you know, we see that sort of thing in the communities. I mean, this fund is available for communities to reach into. Is there a greater reliance on the state for natural disaster assistance than maybe in previous years, where we're seeing, you said 16 of the last 40 disasters have been in the last 2 years, whatever. Is that a greater propensity to just go straight to this fund and ask for assistance, or what do you see in that growth? Just more natural disasters?
Director Kelly.
Mr. Chair and Senator Johnson, the first part of the answer to your question is that over the past 2, 3, 4 years, we have seen a greater number of incidents and greater severity. And by that, I mean the damage done locally. I really can't answer the question about are they quicker to rely on the assistance from the state. I would tell you that they are having more and more frequent experience with events that qualify for either federal or state disaster assistance. So we have some charts that show what's happened over the lifetime of this account, and I can just tell you that is, it goes up, if I got this right from your perspective, it goes up to the right as we move forward in time. We're seeing more events, and we're seeing higher dollar value of damage. And I hope that answers your question.
Senator Anderson.
Thank you, Mr. Chair. Commissioner Kelly, you mentioned there's 1,400 cities, counties, townships. Are they all underneath the requirements here of where the president has declared a disaster? Are these requests of the 1,400, do they fit under that umbrella of the governor or the disaster crisis that the president has made?
Director Kelly.
Mr. Chair and Senator Anderson, of that 1,400, right around 1,100 of those are underneath those 3 presidential disaster declarations, and the remaining 300 fall under those gubernatorial declarations.
Okay, thank you.
Any other questions? Director Kelly, how much money-wise do you anticipate your need in 2021? Do you have a breakdown on that?
For our known disasters, Mr. Chair and members, for what we know and what the state is already committed to helping, in order to provide the resources that we think we need that first $3 million. The balance of that $27 million is what we forecast based on our experience over the last couple, 3 years that we will need. But for known obligations, the first $3 million is for all disasters prior to this point in time. And I think as we look to the future and we look at flood forecasts and we look at our previous experience, we think about the things, the rains that affected Senator Johnson's part of the state last fall. We just know that there are going to be requirements for either state or federal. But there's no real way of predicting that because that's really tied to the weather. But based on past history, that's what we
In the known disasters, do they include estimates of others, or is it a hard number?
Mr. Chair, those are estimates. And one of the beauties of the contingency account is that money is able to flow back and forth from the main account into the allotments that we set aside. So if an event we project is going to cost $2 million and it only costs $1.8 million, we're able to flow that money back into the account. On the other hand, if it costs a little bit more than we project, then we have the ability to create or correct those deficiencies without having to come back for legislative action, which is what we had to do prior to this. But the numbers that we are projecting are based on estimates. The important thing is for the local communities to get reimbursed for their actual costs. But for budgeting purposes, we're using those estimates.
Okay. Any other questions? We do have other testifiers, Senator John Bowen and Ben Klinger.
Thank you, Mr. Chair.
Thank you.
Thank you.
Director Bowen, welcome to the committee. Would you identify yourself for the record?
Yes, Mr. Chair. My name is John Bowen, Crow Wing County Emergency Management Director. I'm also here on the part of the Association of Minnesota Emergency Managers, AMEM. This count in the past has been very helpful locally. We were one of the counties that got 2015, 2016, we had 4 state disaster declarations, 3 in 1 year. 2015, we had the Brainerd Lakes blowdown, which this fund helped tremendously with the recovery efforts from debris removal, opening roads back up, and then the long-term recovery from those storms those years. I just want to say thank you, Mr. Chair, and thank you, Senators, for our support in the past for this. It's been really hits home for local people. You look at some of the townships out there that may only have $10,000 for debris cleanup for a summer, and they get one of their roads washed out or have $600,000 worth of cleanup. So this really does a good job back to the local cities and townships. So thank you very much.
And Mr. Klinger,
Mr.
Director
Chair.
of Winona County Emergency Management.
Mr. Chair, for the record, Ben Klinger, Winona County Emergency Management. Thank you for having us testify about this. In the last year, Winona County's benefited from this twice, and really our townships who've benefited the most from the disaster assistance account. In the spring, we were involved in spring flooding, and the spring ended up being a federal declaration, but we still were able to get 100% reimbursement with the 75% from the federal and 25% from the state. And then in July, we had a flooding event that was really localized, so it didn't raise to the level of a federal declaration. So without the disaster assistance account, it would have been harder to get assistance for our townships. I had one township that had roads washed out that had $200,000 damage of township roads, which is 10 times more than their budget for roads in a year, just one instance. So just asking for the continued support of this disaster assistance account so we can continue helping our local units of government.
Are there any questions for these testifiers? Is there anyone in the audience who wishes to speak for or against this bill? Hearing none, Senator Ralph, move Senate File 3564 be recommended to pass and sent to the Finance Committee. All those in favor say aye. Aye. Opposed? The motion prevails.
Thank you, Mr. Chair and members.
Senator Pappas. Senator Pappas.
Statement from a Minnesota child bride. I was 15 years old when I met Dave, who was 21. We went on a couple dates before I became pregnant. 3 months later, we were married because Dave could have gone to jail for what had happened, and I was told that this is just the way it has to be. I had just finished grade 9 and did not get to go back to school since I was expected to stay at home with my son. By the time I was 19, I had 3 kids, and when I turned 20, Dave decided the children were too much work, and he left. Throughout my life, I was turned away from many opportunities because I was told that my story was not one people wanted to be associated with. But my story was not my choice. My choice was taken away from me when I was told this is just the way it has to be. So thank you, Mr. Chairman, for the opportunity to present this bill, which closes the loophole in Minnesota law which currently allows child marriage. Currently, a parent of a 16 or 17-year-old can petition the court to allow their child to marry. Senate File 1393, House File 745, which we actually have before us, removes that exception and implements a flat age of 18 as the marriage floor. Most of us think that child marriage is something that happens in other countries. And that's true, more than 650 million women and girls alive today were married before their 18th birthday. But out of that estimate are nearly 250,000 children who were married in the U.S. between 2000 and 2010. Most were girls, and most were married to older men. The rationales are often the same, whether in some far-off country or in the U.S. To escape poverty, girls are expensive to feed, clothe, and educate. To reinforce social, religious, or cultural ties, child marriage crosses all cultures and all religions. To provide protection and to protect the perpetrator from charges of abuse or statutory rape, as in the case I read you earlier today. Mr. Chairman, I have 3 witnesses who will go into the details on the educational, legal, and health barriers connected with child marriage. So with your permission, I'd like to invite Claire Willett to join me, and also if Rachel Carlson would come up.
Welcome to the committee. Who is Claire? Ms. Willett, would you like to go first?
Mr. Mr. Chair, members of the committee, thank you for allowing me to speak with you. My name is Claire Willett. I am a senior at Eden Prairie High School in Eden Prairie, Minnesota. Next year, I will be attending the University of Wisconsin-Madison. I will be rowing in the Division I level, I will be studying political science, and I will be pursuing my dream of working in human rights law. I'm lucky enough to have an unimpeded path to do what I am passionate about, but the reality is that not all girls are this fortunate. Child marriage prevents young people like me from reaching their full potential in life. If children who are 16 or 17 are barred from drinking alcohol, getting tattoos, or even voting, why should they be able to enter into the lifetime contract of marriage? Oftentimes, these contracts are lopsided and unfair to the child involved. A child can be coerced into marriage by outside factors, a child can be taken advantage of by older adults, a child can be saddled with responsibilities that are far too great for her age, and worst of all, she loses her ability to be a child. She loses her autonomy and she misses out on formative years to become self-sufficient and independent. Children are not meant to be married. Children are meant to be learning from their mistakes, defining and redefining themselves, and making discoveries. Child marriage devastates the lives of innocent people, and it occurs right here in Minnesota. I'm disappointed that in 2020, only 2 states have made child marriage illegal, but Minnesota can and should follow in their footsteps. Please support Senate File 1393. Thank you.
Thank you, Ms. Millette. We'll now hear from Rachel Carlson. Ms. Carlson.
Hi, Mr. Chair, members of the committee, thank you for allowing me to speak with you today. My name is Rachel Carlson, and I am here to testify in support of Senate File 1393. I am an attorney, and I have worked on human rights issues for many years. I would like to explain what the legal situation is for children who marry and the recourse that married children have if they're in an abusive relationship. The legal age to marry in Minnesota is 18. However, a child who is 16 or 17 may marry with the permission of their parents, guardian, or the court. A child's parents or legal guardian must appeal to the court in order for their child to get married. The judge then decides whether to grant the license. There is no formula for that decision, and judges are left to make their own decisions. Judges usually grant the license because they trust the parent's decision to marry off their underage child, regardless of what the child thinks and regardless of whether the marriage is really in the child's best interest. One reason child marriage is harmful is because whether someone is married or not has an impact on the laws about sexual misconduct. Minnesota has what are commonly known as marital rape exceptions. This means that conduct that would be considered rape is not illegal if the victim and the perpetrator are married. Under Minnesota law, it is illegal to have sex with a 16 or 17-year-old child if you are 4 or more years older than that person and in a position of authority, for example, their supervisor. However, that very same conduct is legal if the victim and the perpetrator are married. Even if the rape or other sexual misconduct came first and then the marriage, prosecutors almost never prosecute these cases because they look at marriage as taking precedence. Consider the victim. She survived sexual assault, but once she is married, that assault actually becomes legal. Imagine knowing that the legal system has essentially written off that crime and given the perpetrator absolute immunity. Finally, I want to discuss the legal recourse for a married child under the age of 18. Children cannot legally sign contracts, rent apartments, or individually hold credit cards. They cannot rent or purchase cars alone. They cannot get access to health care or check into a hospital by themselves. Abuse is common in these relationships. A married child can't file for divorce and can't even get an order for protection on their own because that would require them to sign a contract, and they can't do that if they're only 18, or under 18, sorry. Many battered women's shelters will not accept individuals under the age of 18. I want to really stress that point. A child in an abusive marriage cannot stay in a battered women's shelter herself. They also likely cannot turn to their parents for support because their parents likely gave permission for the marriage in the first place. A child bride or groom who is the victim of abuse often has nowhere to go, and that child remains in the abusive marriage, often with their own children as well. Child marriage is legal in Minnesota, but it shouldn't be. I urge you to support Senate File 1393. Thank you.
Thank you, Ms. Carlson. Senator Pappas, I understand that your third testifier, Ms. Smith, is not able to attend.
Yes, her plane was held up in Chicago. She was
All right.
flying back from somewhere, but I do have a brief statement from her that I could read. Thank you. Thank you, Chair Limmer and committee members, for the opportunity to speak with you. I am a nurse practitioner, and I'm an advocate for the health of all Minnesotans. I also am an international humanitarian aid worker. According to UNICEF, child marriage is a form of violence against children, and it's a public health emergency. I have seen this problem all over the world and here in Minnesota. Most of the children who are married are girls. Girls who marry as children, compared to those who marry at 18 or older, are 3 times more likely to be beaten by their spouse, 31% more likely to live in poverty, 50% more likely to drop out of high school, 50% more likely to get divorced, and 23% more likely to have a heart attack, diabetes, cancer, stroke, and psychiatric disorders. They're undereducated, underinsured, underprotected, and underdeveloped. Child marriage is literally life-threatening to girls. Girls pressed into child marriage often become pregnant while they're still children themselves. Their bodies are too small and underdeveloped. That puts them at risk for obstetric fistulas and other serious conditions. Studies show that girls who give birth before the age of 15 are 5 times more likely to die in childbirth than women in their 20s. A child having a child greatly increases the risk of complications in pregnancy or childbirth. These complications are a leading cause of death among adolescent girls. And the girls' offspring are at increased risk as well for premature birth and death as neonates, infants, or children. If a mother is under the age of 18, her baby's chance of dying in its first year of life is 60% greater than that of an infant born to a mother older than 19. Child marriage is a human rights violation. It violates girls' physical and emotional well-being, and as a direct consequence, the well-being of her family and the entire community. We must end child marriage in Minnesota, and we must end it now. The health and the lives of our girls are at stake.
All right. Is there anyone in the audience who wishes to speak for or against this bill? Hearing none, we'll move into committee discussion.
Mr. Chairman, I just actually have one other story from a victim. This is another Minnesota victim who doesn't feel comfortable going public, but she gave me permission to read her story.
Go ahead, Senator Pappas.
That's okay? Thank you. Pat's story. I'll try to read it fast. I was raised in a family where abuse and neglect were normal. As a result, I was severely depressed, and at the age of 12, I attempted suicide. I called the local crisis hotline and spoke to a man who was a third-year missionary training student. That night, he came to the ER and kept in touch with my parents. He convinced them that he could provide counseling to me and that I didn't need the antidepressants that the doctor had prescribed. I saw him twice a week for counseling. Later that summer, his apartment building caught fire, and he convinced my parents to let him move into our basement. He immediately began molesting me. I became pregnant right before I turned 14. My parents said I could only keep my child if I married him. I was also told that I had brought shame to my family. So in May of 1980, we went on a road trip so I could be married off. We first stopped in Kentucky, and when the judge refused to do the ceremony due to my age, we drove on to Alabama. There, a judge had no problem with the situation, and in a 6-minute ceremony, I was married to the 28-year-old pedophile who had abused me. When the baby was 2 weeks old, my parents could not stop my husband from beating her, and so I was told we had to move out, as though I could stop him. For the next 14 months, I juggled junior high, keeping house, and trying to keep myself and the baby alive around a man who grew more violent every day. I begged my parents for help and told them he would kill us, and their response was that I was a married woman and had to figure it out myself. Eventually, I began counseling to cure my depression and make me a better wife. My therapist asked me immediately how often he beat me, and when I said every day, he promised to help. He had a social worker waiting the next week, and when I walked into his office, 2 weeks later, she came to our apartment with 2 very large deputies. I was taken to a shelter for battered children. Eventually, they removed my child from him as well. Even though a majority of these marriages result in divorce, those divorces cannot be initiated by the child themselves. I was considered emancipated the day I was married. However, I was too young to drive, get a job, rent an apartment, or file for divorce. I had to have a court-appointed advocate act on my behalf. I left school in the middle of the day to go to court for my divorce. I made it back in time for 8th grade English class. She continues on to talk about she then had a drinking problem for 3 years. She struggled with depression. She was upset with her parents. Her church backed her parents. She had chronic PTSD. Her coerced marriage forced her to cover up sexual abuse, and it was a way for her former husband to avoid being charged with a crime. She's middle-aged now, and she still suffers from nightmares because of this. Finally, she concludes, "This didn't happen in a far-off country. I was raised in an upper-middle-class suburban home in the Midwestern U.S. My family looked a lot like yours probably does." Thank you, Mr. Chairman.
Thank you, Senator Pappas. Does the committee have any questions?
I think we have a technical amendment from Ms. Primo.
Ms. Primo?
Yes, Mr. Chair and committee members, this is an amendment to update the dates, the effective dates in the bill. Page 2, line 21. Page 3, line 10. Page 4, line 8. Page 5, line 32. Delete 2019, insert 2020. It makes the same change to all 4 effective dates that are included in the bill.
I'd make that motion.
Senator Pappas moves the oral amendment as depicted by council. Is there further discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? The amendment is adopted. Senator Pappas, there was another technical issue that council just informed me about, and it's one that I'm not sure if you're aware of or not, but we could have council describe it.
Okay.
Oh, it may not be a technical issue.
Is this the Ralph amendment we're talking about?
No,
No.
but we could move on to the Ralph amendment at this time.
Okay.
This is a new issue that council just discovered. So, Senator Ralph, would you like to?
Thank you, Mr. Chair. I think we have an issue here that, and possibly one of the testifiers might be able to shed some light as well on this. Under the Constitution, states are required to honor valid laws or valid acts of other states. And I have some concerns with the provision that says that we are going to, and let me get the actual language so that we don't get it wrong here. It's on lines 3.6 through 3.9. A civil marriage prohibited under paragraph A, clause 4, that is recognized by another state or foreign jurisdiction under common law or statute is void and against the public policy of the state unless neither party was a resident of the state at the time the marriage was entered into. And I guess I have some concerns. First of all, if one person was a resident of the state and one was not, it seems that clearly would be an issue of recognizing another jurisdiction. And even if they were both residents of this state, while I think that I am very much in favor of this bill, I mean, I'm a co-author on it, but I am very concerned that we not get into a question of constitutionality with other states. And so I'm just wondering that whether this is something that we should in fact remove and make it so that this applies to Minnesota, and rightly so, but that if we are going to not recognize not only the acts of other states, but also the acts of other states' residents, even though one of them may have been a Minnesota resident, I think we're going to have a problem. Have you got any opinion on that?
Sarah Pappas?
Thank you, Mr. Chairman. Clearly, that was past issue where they went judge shopping and they went out of state in order to find a judge in another state that allowed child marriage. But I understand your point. I understand if there was a challenge, I wouldn't want the whole bill to be thrown out because of a constitutional challenge. And I'm not sure if that would be the case or if they just make that section void. I think we'd have to add some language that would say if this was determined unconstitutional, the rest of the language wouldn't be unconstitutional, obviously. So Senator Ralph, if it's the committee's desire to not go down this road, we probably still will have that happen. I don't know the rules in other states, if there's a waiting period. You hear these stories about people flying to Las Vegas to get married. But I don't know if, like Wisconsin or Iowa or North Dakota, like here we have a waiting period, right, where you have to get your license,
Right.
and then you have to wait 3 days before you can actually marry at least. And I'm not sure what the situation is in other states. So it does seem to me that rather than risk the entire bill, I would think if this committee's desire to support the Ralph amendment, then so be it.
Senator Ralph?
Yes, I wonder if Senate Council could weigh in on this a little bit. Have you had an opportunity to research the issue or prepare some language?
Ms. Pramo?
Mr. Chair and members, I have taken a brief look at case law on this issue, and I think it's a little bit more complicated, and there's not necessarily a direct answer. So there's several ways to parse it out. The full faith and credit clause provides deference to other states' public acts, records, and judgments. Setting aside the case law and judgments, when it comes to public acts and records, the court has generally been okay in certain situations with allowing states to not recognize the public acts or statutes of other states if there's a legitimate public policy at issue. What makes a legitimate public policy is not really clear. There's not a balancing test under case law. Another wrinkle is that if it is a judgment, however, like a divorce decree or an annulment decree, then in those situations, the case law is much more precise and requires deference from one state to another state's judgment. And when we look at the different laws governing marriages of minors in other states, some of those do require judicial action of some sort, whether it's consent or a petition or approval. For example, under our current law, there is a judicial approval process. So whether that type of approval falls under the definition of judgments under the full faith and credit clause is not necessarily entirely clear, and there isn't specific case law on that point either. So I think it's more of a policy consideration for this committee about what they are comfortable with going forward in terms of the language in the bill about marriages in other states.
I guess just a thought on this, and Senator Pappas, thank you for the suggestion about the severability clause. That might be a partial solution, but I still am concerned that we have a clean bill here. I mean, I think this is an important bill. I am concerned about the judge, or shall we say, this forum shopping to achieve a loophole or a way around this. But I guess I am concerned that we don't risk the good things in the bill. Now, maybe council, again, would it be possible to draft a severability clause that would preserve the rest of the bill if in case there was a constitutional challenge that was raised and was successful?
Ms. Pramo?
Mr. Chair and members, I can draft that if I just have a little bit of time.
Mm-hmm.
Senator Latz?
Mr. Chairman, I'm glad that Senator Ralph raised the issue because I think it's one we ought to factor in here, and I think a severability clause would be the solution. I'd be reluctant to delete the provision itself. Mm-hmm. Just having it in the bill would act as a deterrent to those who would consider forum shopping. And I'm trying to imagine the circumstances under which there would be a legal challenge to this. One of those circumstances would be an attempt by a criminal prosecutor to charge with a crime an older person who violated the law somehow, and then they would try to get out of the crime by challenging the validity of the marriage. So that's one way. I suppose there'd be some civil contest because marriage has so many different implications under our law. where it could have an impact, but probably the most impactful one would be in the context of a criminal charge. But I just assume leave it in there and put a severability clause in. Somewhere down the line may challenge it, but just about every law we pass around here is going to face something. We're accustomed, frankly, to bringing bills through the process every year. When the courts in Minnesota have ruled about the statute's ambiguity that we didn't think was ambiguous when we passed it, and we've got to do some cleanup. So if we have to clean this up down the road, I'm fine with it, but I think we ought to leave this provision in the bill.
Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. I just want to make sure that we're clear with the committee that if you do get married in another state, and it's a child marriage, and neither one are residents of Minnesota, but at some point in the future, they do move to Minnesota, then we do have to legally recognize that marriage. This is only for Minnesota residents who try to get around the Minnesota law.
Mr. Chair,
Senator Ralph.
one other thought, and that is in the blended situation where you have a non-resident and a resident, and there I think there's possibly more risk. I think it's clear that we can probably go along with the idea that neither party, clearly, we would want. But if one party was a resident and one party was not, it seems that there is still a much higher degree of risk there. So I don't want to parse this too much, but I think that maybe it's got to be that only if both parties were residents of Minnesota that we would be able to say no.
Mr. Chairman, and Senator Ralph, I think that's an excellent idea.
Okay. So should we take some time and let counsel do some work here so she doesn't have to do it on the fly?
Ms. Primo, would you like to jump in?
Yes, Mr. Chair and members, one thing I'd just like to point out is that there is a presumption that statutes are generally severable under Minnesota Statute 645.20. It states that unless there is a provision in the law that the provisions shall not be severable, the provisions of all laws shall be severable. The exception is if the court finds that for certain reasons that the unconstitutional provision is so essential and inseparably connected with the rest of the language that that's not actually possible. So we could still add a provision addressing severability in if that is something that the members would like, but I just want to note that piece of it.
Mr. Chair, I would think that belt and suspenders are probably better here. Let's take as many steps as we can to keep this alive. I think if we had some kind of either that or some kind of language of intent that the court can look at and say, okay, no, this is not critical to the bill, although I do feel that it is. I mean, if we get a constitutional challenge to the bill, it's, and I can see an aggressive argument being made that, no, this goes to the enforceability, and why should we favor one person over another? And Senator Latz, I know you've got some experience in this from the criminal side. I mean, I think you raised a good point on that. So I guess I'd prefer to see some kind of even precatory language. I mean, it doesn't have to necessarily be anything other than, look, this is what we intend, this is what we want. In any way that we could make it as clean as possible. But I do think we want to maintain the idea that if there is an out-of-state resident, then I think we have some problems with that.
Thank you, Senator Ralph. Ms. Primo, you might have a suggestion.
Mr. Chair and members, the amendment would read as follows. Page 6, after line 9, insert section 6, head notes severability. If any provision of this act is found to be unconstitutional and void, the remaining provisions of this act are valid.
Does everyone understand the amendment? Senator Anderson.
Could you repeat that one more time?
Ms. Primo.
Mr. Chair and members, page 6, after line 9, insert section 6, severability. If any provision of this act is found to be unconstitutional and void, the remaining provisions of this act are valid.
Sir Letts.
So, Mr. Chairman, I'm just going to raise a point for analysis, not quite sure what to do with it. I think we're all trying to pull in the same direction here. There may be a concern because we don't normally put language like this in other bills, that a reviewing court at some point could conclude in another law that if we didn't put it in that one, but we did put it in this one, that it was not our intent in the other one for the canon of construction to apply. I mean, that is one way that the court, it's another canon of construction that the court uses.
Mr. Chair, maybe we would simply refer to the other statute, say notwithstanding the provisions of, so that it severs the, I see what you're driving at, and I think what we want to do is make sure that we're not trying to go against the severability protections in that statute. So maybe we need to say notwithstanding or something that refers to that statute to express the intent that we're not trying to weaken that by the inclusion of this language. I'm kind of thinking on the fly here, but in answer to someone making that argument, you could at least point to it and say, no, this was specifically aimed at this bill. It was not intended to in any way imply that the statute, the 64520, is to be in some way weakened or otherwise applied to other bills.
Ms. Primo, did you want to make comment on what Senator Ralph has talked about?
Mr. Chair and members, I will say that under current law and as well as other bills, there is language specifying that that provision or that statute or section is severable, and I don't think I would recommend notwithstanding the section in the statute in section 645, because that would, I think, go against the intent of the committee. You have 645's presumption, and then you have just an addition here that upholds or tries to uphold that presumption in case a court is unable to, or based on case law, starts to make a different judgment about whether it is severable or not. So I will say that there is precedent in statute for having severability clauses.
Oh, okay. So in other words, I'm sorry, Mr. Chair. So,
Sorry, Mr. Chairman,
Senator Letts.
Counsel, you think that we're okay if we add a clause without creating any other precedent that'll complicate things?
Ms. Primo.
Mr. Chair and members, I guess I'll say that we've already, as a legislature, started creating that issue if there is an issue, that we've already gone down this path of having several severability clauses in statute. And I'm not sure of any case law that looks at that and then says that somehow that takes away from the presumptions we have in section 645.
Any other discussion?
Mr.
Ralph?
Chair, the only other question is what we would do with the dual citizenship question. And Council's suggestion here, amendment does not address that. It simply is a severability protection. Do we want to, or do we want to just let that go and see what happens? The issue there where you have a resident of another state involved.
Senator Pappas.
Mr. Chair, I think, Senator Ralph, we could introduce a separate amendment to address that issue.
Okay, that works.
I'm not quite sure if council is ready to write such an amendment.
Well, I think it's an easy enough amendment to make. So after we decide on this, I can suggest it.
Senator Ralph, you started the conversation out talking about constitutionality. Then you moved it to severability. Now we're moving it on to splitting or recognizing a split partnership in a potential wedding or a marriage between the difference between two Minnesota citizens versus one Minnesota citizen and one from a different state jurisdiction. I think you started out with an idea for an amendment. Would you want to return to that idea first before we go any further, or are you going down a different path?
Mr. Chair, I'm willing to do it either way. I just wanted to make sure it didn't get, that other point didn't get lost in the shuffle here, that I think we were led to severability over the constitutionality question, and that was protection in case it was deemed to be unconstitutional. I do think then there would be some question about whether we want to add a layer of protection in terms of that dual residence or duality of citizenship question. And that, I guess, would be one that we could consider. My own thinking is that we do add a layer of protection by making sure that the only ones we're referring to are people that are that it is a pure Minnesota relationship. In other words, we feel, or at least I feel, that constitutionally, if these were both residents of Minnesota, there's less likelihood of there being a challenge constitutionality, although there still might be one. So I guess, again, analyzing that, I'm just trying to think it through as to whether it does make a difference, whether there's neither party is a resident. That is clear that I think that we have a problem with. I think that if one party is a resident and one is not, do we have an issue with that? That's kind of the analysis. I mean, I think we've protected the bill by the amendment that council has drafted, but we haven't done anything in terms of the actual challenge that might arise. That's the reason I was then focusing. I'd focused originally on this, but then we came with severability more as a protection than anything.
So, Mr. Chairman, if
Senator
we want to
Pappas?
continue with this, so then, Senator Ralph, would and council, would the language on page 3, line 8, be changed from unless neither party was a resident to unless one party was a resident?
Well, that's kind of the thought.
It's a negative sentence, so I'm
Right,
a little
I know.
confused by it.
That's why I'm having trouble trying to play with the language.
Or unless one party was a non-resident of the state? Which one would it be?
Sir Pappas, we seem to have two concepts that have kind of blurred in and out of each other in the last 20 minutes.
We do.
And we started out with constitutionality question, which is reflected in a A1 amendment, which has not been passed out yet. Then we also have an oral amendment that council created just recently regarding the severability clause. And no one has moved it. And so I tried to get Senator Ralph to give me direction on which one he wanted to go with.
Well, Mr. Chair, at this point, we can go with the severability amendment and then move on to the next.
All right.
And I think that's fine.
Senator Latz?
Mr. Chairman, I'd be curious whether the chief author has any opinion on this. I know we've had bills that included severability clauses before. I don't think it's necessary, and I think existing statute already covers it. And I'm inclined not to include a provision that I think is already covered by existing statute. So it can go either way. I think that's just my inclination on it. So I'm going to not be supporting the amendment, although I do support, as a matter of the record, that provision be severable if it were found to be unconstitutional. So if a reviewing court ever goes back and looks at legislative intent, my intent will be clear on the record, even though I'm going to vote no on the particular amendment.
So what you're saying, Senator Latz, is they're going to listen to this conversation the last half hour or so and try and figure out our legislative intent?
At their own peril, Mr. Chair.
Senator Latz, I've been a member of the Judiciary Committee for a long time, ever since I first started, and I agree with you. There is a standing provision in law that all Minnesota law that's written by the legislature is and should be considered severable by any court. And to write it into a new law would be, I think, a practice of redundancy. And so I would agree with you that I don't think a severable clause is necessary because of the standing that's already in state statute. So,
Mr. Chair, I mean, I'm convinced that from the discussion, and if we feel that it is sufficiently protected by statute, and we don't have to have a special carve-out in the intent of judicial efficiency or legislative efficiency, we could probably leave it out. I would withdraw the amendment.
Mr. Chair?
Senator Pappas.
On the other issue, I'm looking for Ms. Primo. Does it make sense, and Senator Latz, if on page 3, line 8, we strike neither and say one, and then insert non-resident for resident? I think we could do it either way, but I think it's clearer if you say a non-resident at the time the marriage was entered into.
Mr. Chair, I think council has been diligently working there.
Let the experts do it.
Mr. Chair and members, I think the intent is to make marriages entered into other states between two Minnesota residents void in this state. Is that correct? If both parties are Minnesota residents? Okay. In that case, at line 3.8, delete unless neither party was a resident, insert if both parties are residents.
Mr. Chair, could you have council repeat, please?
Senator Johnson requests to have a reread of that amendment. Ms. Primo.
Mr. Chair and members, page 3, line 8, delete unless neither party was a resident, insert if both parties are residents.
Mr. Chairman?
Senator Pappas.
And so just to be clear, if both parties are residents, they can't leave the state to do a child marriage. But if one party is a resident, one party is a non-resident, they could get married in another state. And that's what we're trying to get after. Right?
That would be the
Hopefully help with
intent.
the constitutionality of the issue. Right.
Senator Latz.
So, Mr. Chairman, I got two questions. One is, what is the public policy intent of the author of the bill?
Mr. Chairman, Senator Latz, the public policy intent is to eliminate the loophole that allows for child marriage.
So, Mr. Chairman, if that's the case, it seems to me it's, we want to reach as broadly as we can in that regard without running afoul of a constitutional provision. And it seems to me we have pretty good basis for jurisdiction over a resident of Minnesota, whether it's either party to the marriage. And the only reason we're considering narrowing that to applying only to when both parties to the proposed marriage are residents of Minnesota is over a concern that it may run into a constitutional problem if we're only trying to address a single party to the marriage. If the goal, however, is to try to prohibit these as broadly as we can, which I share, I guess I'm willing to take the chance that some court down the road may conclude that the marriage is still valid because one of the parties was a non-resident of Minnesota. I'd really be willing to take that chance and let the court sort that out. Because I think we have jurisdiction over at least one of them if they're a resident of Minnesota. And if we can prohibit some of those marriages because of that, that's fine with me. And I don't know, I haven't done the research on this. I don't know the answer to the legal question. But if one party to the marriage can't get married, then I think the marriage is null and void, even if the other one could because they're not a resident of Minnesota. So I understand Senator Pappas is trying to find language that would address the question that was raised. But I'm not sure we should try to address that.
Senator Latz, I've been listening to this, and I've been pondering this for a year. And I'm trying to determine, I think we've heard plenty of the caution of people getting married when they may not be mature enough to make that decision. There may be outside pressure from either one of the parties or perhaps a cultural expectation of certain groups that expect a marriage to take place for a variety of reasons. But I also have to think about the other side where there might be a couple that just want to get married. They're young, but they want to get married. One might be 17, one might be 18, going into the military, being shipped overseas, and they both live here. And so if they can't get married in Minnesota, what do you think they're going to do? They both may be residents. One is going to be a future resident, let's say, based in Afghanistan. Or perhaps, and I don't know what it takes to establish residency in other states. Maybe it's just an address. Maybe you have to live there for 6 months. I don't know. It's residency at the time of marriage, as it's written here. So is this really, by writing this as an amendment, are we really creating the impediment that we really think we want? Because I think it might be something that might be easily stepped over. And the other question is, if a couple were married in another state, regardless of what this might be, they live out of state for a year, then they move back to Minnesota. Okay, the youngest marriage participant, who is 17, is now 18. Do we now recognize that marriage, or do we not recognize it because it's a 17-year-old that got married at the time of marriage? So, and is it the purpose of the legislation to annul a marriage because they simply move back to Minnesota? Is that public policy that we want? It gets pretty deep fast, doesn't it? Well,
Mr. Chairman?
Yes.
In response to that, we could come up with a lot of permutations here,
Yeah.
and we can't legislate for every future potential scenario. It's just not possible. Frankly, that's why we have courts, and sometimes the courts throw it back to us to clarify, and that's just part of the process. So my own view is I would just leave the bill as it is, frankly, and have the reach as originally specified here, and if a court determines for some reason down the road that it's not going to be able to honor what we intend here because it hits the constitutional barrier, then, that's fine. That's the process, but I think probably at this point, for me, the best approach here would be determine what the policy is that we want to see become law. If we had a clear constitutional principle that we had to get passed, if we felt that collectively, well, that's clearly unconstitutional, we don't want to pass a law that we think is unconstitutional, that's one thing. But I think there's a lot of uncertainty around this one. So I would come up with the policy that we want to see become law and pass that. And I'd prefer the policy that's written in the bill without any changes, personally.
We do have an oral amendment that was described by council that we're still on. No one has moved that as of this time. Is there interest in moving the oral amendment? And perhaps council would like to repeat it one last.
Mr. Chair, are we talking about the severability?
No.
Or the other one?
We're past that.
Okay.
Council, would you describe the oral amendment that you just recently created? Bring us back to a discussion.
Mr. Chair and members, the amendment was at page 3, line 8, delete unless neither party was a resident, and insert if both parties are residents. And I think the intent here was to make marriages between two Minnesota residents outside of this state void and unenforceable.
All right. Do I hear a motion on that oral amendment? Hearing none, we'll move on to the, to further discussion. All right. I've been told that Ms. Primo has discovered a potential drafting issue. This was the last moment discovery that potentially creates a conflict between lines 3.4 to 3.5. Ms. Primo, would you?
Mr. Chair and members, I don't think this was necessarily a drafting error, but I believe it's just a point to something Senator Ralph may have raised earlier. So at line 3.4 to 3.5, it states that a civil marriage entered into between persons when both have not attained the full age of 18 years is prohibited under this statute. And if you see the statute, it's 517.03, and the marriages that are prohibited in this statute are cited in our chapter that governs marriage dissolution. And 518.01 specifically makes void any marriages that are entered into in violation of 517.03, which is where you see this language at lines 3.4 to 3.5.
I totally didn't follow that. Mr. Chairman, Ms. Primo, I'm sorry, I totally didn't follow that.
Oh,
Because I wasn't even following where was 5.17 and where was 5.3 and.
And Mr. Chair, members,
Primo.
and in addition, I did not finish that train of thought. Mr. Chair, in addition, there is another statute in 518.02, which makes voidable marriages that are entered into under the age of legal consent. So now that I'm thinking through this, you have a statute saying in one circumstance, this marriage is definitely void, and in another circumstance, this marriage is voidable, and those have two separate types of legal effects. So there is a little bit of a conflict there, and then that's a decision for the committee members and the author to make about whether this type of marriage should be voidable, meaning that you would have to go into court and get a judgment that specifically annuls the marriage, and there's some other, fact-based analysis that the courts would have to do, or whether this would be completely void, meaning that it's more of an automatic function of the law.
Mr. Chairman?
Do you have language to correct this? Ms. Primo?
Mr. Chair, I can craft language to correct this, but it is a policy decision and choice for someone, the committee members, or the author to make.
So, Mr. Chairman.
Sarah Pappas.
We're not going back, and I don't think our intention is to go back and void any marriages that still are out there now that were allowed. This law doesn't go into effect till August, so theoretically, we could still allow child marriages until, I believe it's August, August 1st. I don't know that it's necessary for us to make them, in other words, voidable, that the marriage could go to court and become voidable. The intention is just not to allow them in the first place. I think it just could be too disruptive, confusing to people about whether their marriage is legal or not. If we went back.
Sarah Pappas.
You know how you feel about retroactivity, Mr. Chairman.
Mr. Chairman?
Senator Latz.
What Senator Pappas mentions, I'm not sure was the point that council was raising. I think the point council was raising was whether or not the marriage will, as a matter of law, without any other action, simply be invalid because neither the parties weren't of age, as opposed to being voidable, which would take an action going back in court, which is covered by 518.02. So if we allowed, under 518.02 paragraph C, under current law, if a judge allowed a marriage and then for some reason they wanted to go back and void it, the parties want to go back and void it, theoretically they could go back under 518.02 and void it because there's a provision to do that. But I think the question the bill is attempting to do is make it void ab initio. I mean, it can't happen. It has no force and effect of law. In the first place, a marriage never occurs if one of the parties is underage. And that's the purpose of the bill in front of us. So I don't think, that's the policy I would like to see take place, effective on August 1. I think it's a separate question of whether we allow retroactivity. But actually, no, you don't have to even do that because current law would allow for retroactivity. I think, maybe council can weigh in on this too, but the way I read it, under 518.02 paragraph C, an underage marriage that was allowed by a judge now, theoretically, one of the parties could go back and ask for it to be voided under 518.02C. But that's a separate question. We don't necessarily even have to answer that question here today in order to pass this bill for all future underage marriages to simply have no force and effect of law at all. The marriage never occurs.
Senator Latz, if you look at 3.10, 3.11, that's the effective date application. We've already changed the year to 2020, right. But it would be for effective and applies to marriages entered into on or after that date. So there is a point in time where we go prospectively. I don't understand where the retroactivity would fall.
Well, I think Senator Pappas interpreted council's remarks to be addressing a retroactivity aspect, which was not the point I think council was trying to make.
All right.
I don't understand council's point.
So council's raised a point of interaction between existing law and the proposed law. And I don't think they're inconsistent with each other. And I think we can move forward with this bill without making any other changes. Unless maybe council disagrees with me on that. I'm not sure. That's the way I'm reading it for the first time sitting here today.
I'm sure we'll come back to this particular issue, but Senator Johnson, you had a comment earlier.
Just a quick question, Mr. Chair. I was just reading on 4.13, where it says both parties must present proof of age to the local registrar. What is that proof of age?
Mr. Chairman,
Pappas.
Senator Johnson, it's on page 6, section 5, where the proof of age is listed.
Thank you.
Mr. Chairman, did anyone have any questions for my witnesses?
Right. We've had
While we're
two
waiting.
very patient witnesses at our table. Are there any questions here that you may want to direct toward our testifiers?
Otherwise, Mr. Chairman, did you understand the policy distinction that we're supposed to be deciding here? Because that's what went over my head.
It's a little fuzzy right now for me.
It does seem a
Senator
little
Pappas.
fuzzy. So, because marriages for under age 16 are already not allowed. So it sounds like it had something to do with that, but I
Right.
got it wrong the first time, so I don't want to guess again.
Senator Latz.
Mr. Chairman, I've had conversation with council, and I think I think in order to implement the bill, the intent of the bill, we would have to delete a provision in 518.02, which was meaningful under current law, but which would not be meaningful if we passed this bill. And that would be 518.02, paragraph C.
And what does that say?
I don't think we have that in front of us.
That would have to be an oral amendment, which I'm prepared to make.
Why don't you describe what the 518 reference is, Senator Lance, or perhaps council could?
Well, it's easy to say oral amendment, delete paragraphs. Why don't you explain why?
Mr. Chair.
Ms. Pramo.
Mr. Chair and members, I'll read the oral amendment that Senator Latz is referencing. So it would be adding a section to this bill, section 518.02, and deleting paragraph C. And paragraph C states a party was under the age for marriage established by section 517.02. And I understand this statute is not in front of you, but this would remove from a statute that governs when a marriage is voidable, the ability of a party who's under the age of 18, if this bill is passed, to go into court and be required to go through the court process to make a marriage void. Instead, because of the changes that are being made in this current bill, it would reference another statute which lists when marriages are automatically void by function of statute. And so then a marriage that's entered into under the age of 18 would then be automatically void without at least needing the judicial process.
I'm having one of our research staff get a copy of the 518 reference. I feel very uncomfortable considering a change in law when I don't have it in front of me. I think we'll open it up for further discussion if someone wants to weigh in. You're going to the microphone, but you're shaking your head no.
Well, I do have the statute up in front of me. I've been looking at it, and when council raised the issue, I think it's a valid point that we're, and I think this is what Senator Latz was trying to address, that we do have a conflict at this point because one says it's voidable and one says it's void ab initio, and we have to resolve that conflict. I think that's the key here. So that by amending 518.02 to remove the reference to 517.02, I think you clear that. I think you take care of that. So. But that was a very good catch by council, I might say.
While we're waiting, we do have one other bill that we could move on to, lay this one temporarily on the table with the intent of getting back to it today. So, Senator Pappas, I would lay this bill on the table at this time. Senator Johnson, we're going to move on to Senate File 3348. Senator Johnson.
Well, thank you, Mr. Chair. Hopefully, we'll give the council enough time to make this amendment. This is a fairly straightforward bill, so while we're occupied with that, we'll go over some of the details then. So this is a bipartisan bill that was brought to us by the Community Association Institute, and Patty Fisk, who is the president of the old Shakopee North, Park North, which is not to be confused with the new Shakopee North Homeowners Association in Bloomington. She's a constituent of Senator Wickland, who is a co-author on the bill, along with Senator Anderson over here.
Senator Johnson, I understand you have an author's amendment?
We do. Would you like to take care of that first?
Yeah, why don't we move that now? Senator Johnson moves one author's amendment I've been told it's technical. All those in favor say aye. Aye. Opposed? The amendment is adopted. Senator Johnson, please continue.
So homeowner association are common not-for-profit corporations are governed by certain documents. You have the Articles of Incorporation, the bylaws, and then the declarations. So today we're going to be dealing with the declarations. Declarations are set forth, they set forth the rights and responsibilities of the owner, the residents, and the board of directors. It covers such things like who's responsible for the repair or plowing the parking lot, things such as that. The declarations at the old Shakopee Park North require 80 to even 100% of all unit owners to approve an amendment. Now, unless you're on the AG committee, you usually don't see that very often. So, you know, yep. So what we're trying to do here is give an avenue then for building owners to make changes to the declarations through some court procedure here that would be able to allow those owners to make those changes. So today, to talk about the details, I'd like Ms. Fisk to testify on some of the changes that we're proposing to make.
Welcome to the committee. Would you identify yourself for the record?
Good afternoon, Mr. Chairperson and ladies and gentlemen of the committee. My name is Patsy Fisk, and I'm the president of the board at Old Shakopee Park North. Our building was built in 1978, and our Articles of Incorporation, our bylaws, and our declaration were also created in 1978. Now, the good state of Minnesota has made new laws and rules and regulations and statutes since then, but our declaration says we have to have 100% of all of our owners approve any updates, and none of the previous boards have ever decided that they wanted to try to do that because they didn't think they could get 100%. So the law we're presenting today is that if we got 67% of our owners to approve of updates and amendments, that they could then go in and be in effect. We've had a lawyer create our new governing documents, and what he did was just put all the new Minnesota laws into it. Like in our old governing documents, it said we couldn't have any children in our building. That's illegal and unlawful, so he took that piece out. In the old governing documents, it said when I want to mail minutes of the board meeting, I have to do that with a United States mail and a stamp. The new governing documents say I can do it in an email. The new governing documents say that the board can assign a parking spot in our garage so that we don't just have haphazard parking. There's really, the only changes and updates we did were to make us legal with the new laws in the state of Minnesota. So we really want to go to 67%. We've been working on this for about 6 months, and we had our 67% when we had our first meeting, but our governing documents say 100, so we're still working on it. We'll probably work on it forever. I really need you to say that this is the new law.
So, Ms. Fisk, what you're saying is your document is a little too difficult to get a quantifiable majority to vote in favor of changes because of the original document.
Because we can't get to 100%.
Right.
Yeah.
All
Yes,
right,
sir.
we'll move on to Mr. Hines. Mr. Hines, would you identify yourself for the record?
Thank you, Mr. Chair and members. My name is Patrick Hines with Messerly Kramer, representing the 650 members of the Community Associations Institute, which represents the interests of the over 7,000 homeowner associations in Minnesota. I'd like to thank Patsy for bringing this issue forward. It is an issue that a number of associations face where they simply can't get to 100% in order to amend their declarations. So this bill would create a court process where Old Shakopee Park North, for instance, once they've asked for and received approval of 67% of their members, they can petition the court for a hearing, and they would then have notice of that hearing and serve it on all the residents and mortgage holders. And after that hearing, the court could then issue an order granting the amendment to the declaration if it were viewed in the public interest. And in order for it to take effect, the community association would then have to record that amendment with the county so that it was of record. There are a number of provisions restricting the types of amendments. This is really designed to be something that is non-controversial. We worked with the MCIWA subcommittee of the Bar Association in the summer and the fall, and they are okay with this language. We've circulated it to all of the usual groups who care about these bills, and we have no objections. Thank you.
Mr. Hines, I'm a little familiar with homeowner association documents. I would think a 67% would be a high bar to begin with as well. Has there been difficulty in other associations getting, do you have any record of achieving a 67% participation?
Mr. Chair and members, you're correct, 67% is still a supermajority, but the associations we've spoken with, that has been far less of an issue to reach, especially for amendments that are like those type that Ms. Fisk is looking for, non-controversial amendments. Obviously, if something were more controversial, they might not reach 67%, and that's one of the reasons we kept it there. We wanted to limit this to really non-controversial, good governance type of amendments.
All right.
Thank you.
Are there any discussion for our testifiers? Senator Pappas.
Mr. Chairman, as a member of an association, I live in a condo, I strongly support this bill. I know how tough it can be.
I remember being a realtor, I sold my mother-in-law a condominium. And she went to her first homeowner association, and it was her first and only time she went to a homeowner association meeting where they discussed painting the common areas that needed the paint in hallways and foyers. And there was a 3.5-hour discussion on what shade of beige would be painted on the walls. And I think that's the reason why she decided never to return to an association meeting. And then trying to find 100% agreement is, like you say, impossible to get.
Mr. Chair, that kind of sounds like a judiciary hearing right there.
Oh. You did want your bill to pass, didn't you, Senator Johnson? Senator Ralph?
Thank you, Mr. Chair. Actually, Mr. Hines, I'm reading on page 6, the paragraph 7. Is it my understanding that the object here is kind of, that we're talking about consent, is to try and take this kind of from the idea of affirmative consent to simply saying that consent is deemed to have been given if the following things are followed? Is that what, am I reading that correctly?
People have, excuse me.
Go ahead.
Good afternoon, Mr. Chairperson and Chair, whatever.
Yep.
Yeah, people have to sign their consent. They can't just say it's okay. They have to sign it.
Mr. Hines?
Thank you, Mr. Chair, and Senator Ralph. Just to clarify, and thank you for that question. I was trying to speed up the testimony, and I didn't speak of that paragraph. There's a provision in existing law where if an association sends a requested amendment to a secured party, like a mortgage holder, and the mortgage holder does not respond within 30 days, their consent is deemed to have been given. So we've taken that concept and placed it into this bill for unit owners. And what that section you're referring to says, if we properly serve a unit owner and ask for their approval of an amendment, if we don't receive an answer within 60 days, then their consent is deemed to have been given in that case.
Thank you, Mr. Chair. I just wanted to clarify that.
All right. Mr. Hines, there was testimony regarding the reliance on email rather than U.S. postage. If one of the residents didn't have access to a computer, do they have to be mailed via U.S. mail? Is that in this provision?
Mr. Chairperson and committee members, if people don't have a, what, sir, what?
I have to announce on the microphone who's talking.
Thank you, sir.
So when you begin talking, I have to label you.
Okay, thank you.
So Ms. Fisk, please participate.
We have 12 owners in our building that do not have computers, and we each have a mailbox outside our door. So we print out the minutes of the meeting and the things that they need to know and put them in their mailbox outside their door instead of put it in United States mail. It's
Now-
much cheaper that way.
Now, Ms. Fisk, when you do that, that may work in your buildings, but is that the way it works in every other building? Does there have to be a alternative communication method rather than rely just on email? So we make sure that everyone has access to what might be happening in their association.
Mr. Chair, so two things. The question of whether Old Shakopee Park North amended their own declaration to provide email service is one question, and then there's also the issue of what the underlying statute, the Common Interest Ownership Act, requires in terms of service. And I would have to look at the underlying statute to remind myself what it says about service. So I'd have to get back to you to answer that. But the statute, to the extent that the statute has its own requirements about service, so for an amendment, for instance, that would control over the declaration. So if there's a specific statutory requirement to receive notice by mail or by other service, amending the declaration would not change that.
I understand that, but there is reference to relying on email. And my line of questioning is just to make sure that proper notice, I hope we all recognize proper notice of a homeowner is necessary for the good working of a homeowner association. Are we relying, if this bill would pass, are we relying only on email as written in law? Or is there other provisions that recognize an alternative to making sure that homeowner gets the proper notice?
Thank you, Mr.
Is
Chair.
that in the bill, and could you point at it?
Thank you. Mr. Chair, members, sorry, my answer before was not on point. This bill does not make any changes in terms of notice by providing alternative notice by email. All of the notice requirements in this bill are by certified mail, return receipt requested. So nothing in this bill would loosen up any notice requirements like that.
All right. Any further questions? Is there anyone in the audience who wishes to speak for or against this bill? Seeing none, Senator Johnson moves Senate File 3348 as amended be recommended to pass and go to the floor. All those in favor say aye. Aye. Opposed? The motion is adopted. Thank you.
Thank you
all.
very much.
Thank you. Yeah. We'll now go back to Senator Pappas's House File 745. I think it's fine if you just stay where you are. I would ask that any testifiers might hang around a little bit, just in case we need your expertise. All right, where were we? Senator Pappas.
I'm sorry, Mr. Chairman, as I understand, the discussion is between when a marriage is voidable and when it is void, and so I think that Senator Latz and Ms. Primo were having a discussion about that and maybe came up with a solution that we don't need to do anything. Is that true, Ms. Primo? Or is there a disagreement?
Ms. Primo?
Mr. Chair and members, I think there was a concern that because this bill is effective August 1st, 2020, and applies to ongoing marriages, that perhaps leaving in place paragraph C in 518.02 for marriages that have been entered into pre-August 1st, 2020, so that there's a path for those persons to go into court and seek a different status on their marriage, that maybe for now it would be best to leave that in place and perhaps do a little bit more research on this specific point to see if there is a conflict. practically speaking, just thinking through this, if a marriage is void under 518.01 and someone goes into court under 518.02 and seeks to make the marriage voidable, perhaps practically speaking, the outcome is somewhat the same, so so both provisions could potentially be consistent. So that I'll just have to do a little bit more research on that specific point, because I'm not aware of a situation where a marriage is both void and voidable, and how, if there are any issues that may come up in that situation.
So, Mr. Chairman,
Pappas.
from a public policy perspective, you know, if a couple got married and one was underage, say 17, and they've been married for a period of time and it's worked out for them, we wouldn't want to automatically void their marriage. But if they were married and maybe one of them is still underage and we pass the law, there would be a path for that probably young woman to be able to make her marriage voidable by going to court. But at least it doesn't automatically throw everyone out without kind of letting them know. And so people who think they're married suddenly find out they're not. But yet for a girl who's having a very difficult marriage, there would be a path for her to go to court to have it voided.
Sir Pappas, it could be a young man as well, right?
Could be a young man as well. Mr. Chairman, you're right.
All right. So we have no amendment at this time. We have the marriage stand, or the marriage stand, the bill stand as it was amended. Is there any further discussion on this bill?
So, Mr. Chair, just for clarification, as I understand it at this point, we're not doing anything in terms of this issue of the void or voidable, and we're just going to go forward, and would we be looking at then some possible amendment before this comes to the floor, or what's the route on this bill? Is it going to the floor, or where is it going next?
Senator Ralph, this is intended to go directly to the floor. And I can only imagine the discussion we'll have on the floor, despite the fact that we like to solve problems before we send them to the floor. So if there's any propensity for that, we'll have a lively time on the Senate floor regarding this bill. Is there any other further discussion? Hearing none, Senator Pappas moves Senate file, or House File 745 as amended be recommended pass and move to the floor. All those in favor say aye. Aye. Opposed? The motion prevails.
Thank you, Mr. Chairman and members.
If there's no further business before this committee, we stand adjourned.